Good afternoon, everyone. Thank you all for joining us today for Foundations of Federal Indian Law, part one in a three-part tribal consultation series. My name is Kara. I use she, her pronouns, and I'm the program coordinator at the Partnership for the National Trail System, or PNTS, and I'll be serving today as the webinar moderator. I'm speaking to you from the lands of the Onondaga and Haudenosaunee people. PNTS recognizes that land acknowledgements are an important first step in acknowledging that we are on stolen Indigenous lands. There will be a link in the chat where you can explore what Native lands you currently reside on. Please let us know in the chat what lands you're joining us from, and also introduce yourself and let us know what organization you're affiliated with. PNTS recognizes the need to commit further and engage in meaningful partnerships. PNTS is committed to working with Indigenous people, organizations, and communities, and having Indigenous people lead the way through initiatives such as this tribal consultation series led by Indigenous professionals. Our commitment proceeds into the future through projects such as the Indigenous Mapping and Research Project, which provides resources to help advance National Trail System awareness and education of Indigenous knowledge and stewardship. As folks share in the chat and reflect on that, we will get started. This webinar is being recorded and will be available to everyone that registered following the live presentation. The session today will go for about 45 minutes, and we will have time at the end for Q&A with our presenters. Please feel free to put any questions or comments into the chat as we go. For those of you who may not be familiar with PNTS, we are a small nonprofit that is a collective voice, a resource provider, and a hub for exchange, learning, and action for the National Trail System. As the only 501c3 nonprofit organization focused on the 30 national scenic and historic trails, PNTS brings together professionals, leaders, and trail and hiking enthusiasts to promote a thriving, accessible, and inclusive national trail system. On behalf of PNTS, we would like to thank the National Park Service, Bureau of Land Management, and Forest Service for their leadership in helping to develop this tribal consultation series. And additionally, PNTS would like to express gratitude to the Native American Rights Fund for their leadership and participation to make today's session possible. Now it's my pleasure to introduce today's presenters, Brett Lee Shelton and Joe M. Tenorio with the Native American Rights Fund. And now I'll hand it off to Brett to get us started today.
Thanks, Kara, and thanks for coming, everyone who's here. This is pretty exciting. I'm gonna go ahead and work on sharing my screen right now. I have a bit of a PowerPoint to share as we talk today. So just bear with me while we get it started up. Okay, that should do it. Yeah, so thank you very much. I'm Brett Shelton. I'm a member of the Oglala Sioux tribe, and my nation is the Oceti, Sakowin, Oyate, and I'm starting to recognize that in line with a movement among our people who are Dakota, Nakota, and Lakota people that we need to call ourselves by our original name and start to reunify our nation that way. And so I'm starting to get used to putting that out there as well. And then Joe, do you want to introduce yourself too? One of my colleagues, Joe Tenorio, is also presenting with me today, or backing me up when I need it.
Sure. I am Joe Tenorio. The slide there says I'm from Santo Domingo Pueblo. But as your prelude suggested, my tribal name in our native language is Kiwa. So that's what we call ourselves from home, getting back to our traditional roots. I am a Kiwame, and that Santo Domingo Pueblo is the Christian version of the tribe.
Yeah, so that's a little foreshadowing of something that's going on more and more around Indian country today. Our assumptions today with this talk is that we'll have a lot of people with very little background in federal Indian law and the history relating to that and federal policy and so on. So this is going to be a really high level overview, like a helicopter view plus, maybe more like 30,000 feet, Joe said once. We're just going to kind of cover over, because we're talking about, several centuries of history here, and it's tough to get into too much detail, but you will learn more about, specifically current policies and laws around those policies, around consultation and interaction as the series goes on and start to drill down some more. But this just provides a good background and provides some roots, would be another way to look at it for folks to look at and better understand the way things are now, because they can get pretty complex, and there's good reasons for that because of the way the policies rolled. So a little bit first about our employer, the Native American Rights Fund. That's a nonprofit law firm that was founded 52 years ago. And basically they've been at the front edge of Indian legal issues as they proceeded since the civil rights era when they were founded. We've always taken cases based on these priorities that are listed here. These are the factors that we look for. And if a case pursues these things, then we highly, we consider whether to take it up or not if we have the resources to do it. It's a nonprofit law firm, so we're always in need of more support. And if we could have infinite resources, we could do a heck of a lot more than we do now. But it's a great place to work. And for people like Joe and I, it's like a dream job to be able to work on these things and to work in an organization that carries with it such history and expertise in all sorts of areas. It's great working with all our colleagues. There's our website in case you wanted to learn more. We have mailing lists and so on, so you can sign up there or just poke around on the website, all kinds of resources. And then to talk about tribes, just a very brief overview. A lot of people don't even know how many tribes there are. 574 at last count that I'm aware of. I think that's still accurate. And those tribes are highly varied across the country because of varying history, because of the geography and where people come from originally, creates different cultures and so on. Just the amount of variation is really amazing. And a lot of Americans aren't aware of that, so it's good to point it out. The best I can tell, looking at census data from 2012 was what I found. There's about 5.2 million Native Americans, Alaska Natives. At contact, there's reported to be about 60 million. That figure at contact is a little bit tough to pin down, but that's just based on looking at several articles, and researchers in that area are starting to come to more of a consensus, and that's representing a better consensus than has been had in recent decades. At about 60 million seems right, or that's what the experts seem to agree on right now. Given what we've just been through and what we're still kind of going through with COVID, I think it's really interesting to point out that there was a wave of great deaths or pandemics early on at contact because people in this hemisphere hadn't been exposed to diseases that were carried over from colonizers coming from Europe. And it's generally accepted that there was about a 90% casualty rate, so that about 56 million people had died from basically diseases by the early 1600s. I always just kind of glossed over that, but the experience of the pandemic kind of made that more real to me. A lot of folks in Indian country lost a lot of people. We were hit pretty hard, and I personally know of 25 friends and family that I lost, and people I would have liked to have seen again. I don't think that my case is very atypical. I think it's probably common, and I know of a lot of people who lost more. And that was really tough. I remember one week where I learned about 3 people during that week that had passed from the virus. And that was really tough. That one broke me down. And then now when I think that was 25 people out of all the people I knew, what if it was a 90%? What if it was a 90% mortality? It's hard to get my head around how awful that must have been, but now I start to see what it must have felt like and how traumatic it might have been. Most of the time that happened a long time ago, but there's this book that I reference at the bottom of the slide here, Uyarak, written by a Native Alaskan man, where they had a 60% mortality rate from a pandemic in the 1900s, and they called that their Great Death. And he talks about what it was like for him during that time. And I just like to put that out there. Their group didn't have the earlier pandemics as much, but this wave hit them at that time because they're way further west and they were remote. So they got by fairly unscathed from the early ones that we're talking about initially. But he describes what their experience was at that time. Okay, onto the law. It's important to note, and the scholars are starting to realize more that this is an important distinction to make. There's 3 types of law that basically govern Native Americans' lives. The first that I like to talk about is the tribal law. This is called natural law a lot of times in our communities because it's derived from basically living our way of life and in nature. this law is typically encoded in native languages, and some tribes will legislate it now as well, pieces of it anyway. They'll put it on their books as part of the tribal law. But this is the way that the tribe does things, and it was in existence prior to the imposition of any law by any outsiders as well. And it's frequently what tribes use to govern their affairs internally too, still. And like I say, it may or may not be written. Typically, it's understood a lot better through the native language of the people who you're dealing with. Then there's federal Indian law. That's basically the law of the colonizer. That's the law of the United States that basically describes and governs how it deals with Native Americans. So it's important to realize what this is, and it's important for us to learn this on the native side of things, because these are the rules that the United States plays by, basically. And this is the primary activity of the Native American Rights Fund, is to deal with federal Indian law. Although I'm fortunate to be one of the people at our employer who gets to work a lot more with tribal law as well. The progress of federal Indian law over time has basically been a swinging pendulum. This chart here represents how that pendulum has swung over time. It seems to go between a preference for assimilation of Indian people into the larger culture, and on the other side, the other end of the spectrum, towards self-determination by Native people of their own affairs. And as history advances, it kind of vacillates between those two. We'll come back and talk about that a bit more in a sec. But back to the third type of law, which is international law. Now, this is the law of the different nations around the world. And there's a tension in this law between a preference for facilitating markets, making trade easier for companies and businesses from one country into other countries. But also there's a movement to try to help curtail abuses enacted by governments against indigenous people via colonization. So that tension between facilitating markets and curtailing abuses is there and in effect. So you can see different laws that kind of are aimed to achieving either of those ends. Most recently, there's the Declaration on the Rights of Indigenous Peoples, which is the United Nations put that out, and that's designed to help curtail abuses of colonizing nations on indigenous peoples. And that represents basically a compilation of international rules that nation states need to observe when they're dealing with indigenous peoples. Now, we would like to see a lot more of that done within the United States if we can. The United States was one of the last adopters of it, that they really only recognized it just a decade ago, basically. Now onto federal Indian law. This overview, you could see this in a Kaiser Family Foundation article. I'll send that over to Kara so that she could provide it to anybody who needed it. Basically it talks about the different, the chart represents the different policies that have existed over the decades with respect to Indian history. And this vacillating back and forth is the vacillating between preferences for assimilation and for self-determination. And we're going to talk about each of these periods in a little bit more detail now. First off, looking at the earliest roots of federal Indian law, it's important to point out that before the US, tribes had full sovereignty. They just did what they needed to do, what they thought best, and full self-determination. There was no issue about a policy preference for assimilation versus self-determination. And then upon contact, it became clear really soon between the colonizing nations that they needed to deal with disputes between themselves. So they came up with the doctrines of discovery, which basically said that whoever among the colonizing nations was first to discover land between themselves, remember, because there were already people here, whoever that first discoverer was among the colonizers was the one who had the right to that land eventually. It left open the question of how do you deal with the people who were already living there, and that's where the doctrine of conquest came up, that basically the discovering nation had the right to then acquire the land by conquest or treaty making with the people who were already there. And so that's what the United States succeeded to when it declared its independence from Britain. It basically said, we're going to take over. So it took over Britain's role in that system. And so that was what happened in the Declaration of Independence. The US made its first treaty with the tribe, I believe in 1787 with the Delawares. England had previously entered a lot of treaties with tribes all along the East Coast in the English colonies at the time. So those already did exist, but the first US treaty was in 1787. Just as kind of a side note, the US quit entering treaties in 1871 when it decided it would have a different approach to Indian affairs. And we'll talk more about that time period later. I think it's important to point out that things were not always very nice at the time. This Lord Jeffrey Amherst in 1763 advocated for biowarfare basically against the local tribes by calling for smallpox blankets distribution among the tribes. And there's a quote from him there. And of course, this is a man that Amherst College and Amherst, Massachusetts are named after. And we have this issue with place naming a lot, where a lot of people a lot of places, the people that they're named after were basically Indian fighters, Indian killers. And that's part of the history of the United States that people are working to undo as well. Just this one example, history's replete with these sorts of examples. But once the United States said that it was going to take over England's role in this system, it eventually developed the US Constitution, and that provides the basic groundwork for the rest of federal Indian law in the United States instance. And the two places where this is apparent, or where it's rooted, is in the Commerce Clause, where it's stated that Congress shall have the power to regulate Congress with certain parties, including the Indian tribes. And then the Supremacy Clause, where it says that the Constitution and the laws of the United States and all treaties made under the authority of the United States are the supreme law of the land, and every state shall be bound thereby. So basically that says that the federal government has the primacy in Indian affairs in dealing with Indian tribes, and the states don't. So there were some early Supreme Court cases that kind of assessed out and mapped out the way this relationship was thought to exist. Based on those theories. And the first case that people usually point to is Johnson versus McIntosh from 1823. This case dealt with the grant of land by tribal leaders from the Piankashaw Nation, which I think was in Illinois or Indiana, I can't remember, in the 1770s. And these grants of land by the tribal leaders to other non-native individuals were held invalid by this case. And the court explained what happened, and it explained the doctrine of discovery, as I described just a couple minutes ago, where basically the discovering nation had the right to acquire the soil from the natives as against all of the other colonizing nations. And that the Indians retained a right of occupancy, which only the discovering sovereign could extinguish by power, by conquest. And so the colonizing nation that ended up with these rights by these doctrines was able to then grant title to other people. But that title was still subject to the Aboriginal title of the natives until the Aboriginal title was dealt with. And so that's been called Indian title or Aboriginal title. And we still refer to Aboriginal rights, even to this day, with certain rights that haven't been extinguished in the United States system. The next case that came up was the Cherokee Nation versus Georgia. And in that one, the state of Georgia had been attempting to extinguish Aboriginal title of the Cherokees. The Cherokees brought suit, basically claiming federal court jurisdiction as a foreign nation. But the court said, no, we don't have jurisdiction to hear the case. Tribes are nations, but they're domestic dependent nations, not foreign nations. They're not foreign states. So there wasn't jurisdiction to hear the case on that ground. So then the next year, Worcester versus Georgia came up. And this one involved a state conviction of missionaries who didn't get a state license to operate in Cherokee country in Georgia. So Georgia had this rule that if you're going to do missionary work, you need to get a license. They were in Cherokee land and they didn't get the license. The Supreme Court eventually said that there was no jurisdiction for that case. There's no state jurisdiction in Indian country. So that kind of lays the framework. These three cases are kind of seen as the most ground establishing cases.
Brett, can I interrupt here?
Yeah, please.
So one of the comments that just came through wanted us to discuss about the Castro Huerta case, and its reference to this Worcester within that opinion. Can you speak to that, or I mean I can chime in as well.
Boy, I'm not ready to do that very competently yet. Everybody's still kind of digesting that. We have a work group of attorneys at NARF who's kind of going through and trying to figure out what's next and everything. But the danger is there. I don't have time to go much into the background, but this was set up by another case that basically had established that there was tribal jurisdiction still in Oklahoma in places that were originally reservation lands of the tribes. So basically the reservations survived. And then there was within the last few weeks a Supreme Court case that said that the state still has jurisdiction on those lands. And that was kind of in contravention to both the earlier case and to Worcester versus Georgia. And the fear is that an awful lot of jurisdiction has been eroded in that states have an entree into a lot of tribal lands all around the country. Now, the situation in Oklahoma, like in many places, is really unique to that place. And the status of lands in that area has been determined by a unique history. So I hate to universalize too much, and that's something that people are talking about. And we'll learn more in this. I mean, this presentation isn't meant to drill down on the Castro Huerta case either very deeply, but that's what's at stake right now. I mean, this 1832 case appears to have been undercut or almost overruled by the Supreme Court, by an actively aggressive Supreme Court. And so we're worried about it. Where we push back is with different histories and so on too. So we'll see. And this presentation is going to talk more about those different histories and just provide the basic overview of what people are, of what the differences can be and flag where some differences are. And then you have to look into the history of the individual places to get more detail. Joe, did I miss anything that could be said too? I hate to just dismiss the question too much.
No, I think what I would add to that is that the reference to Worcester comes within the context of that case, the Castro Huerta case, which is criminal in nature. And I think that there's a lot more precedent out there, binding precedent, that talks about the lack of state jurisdiction when it comes to a civil regulatory type, which I think is what will be forthcoming in the next series or two when we talk about the policies that govern trails and so forth. So that much I think I would distinguish from the impact that Castro Huerta may have with respect to civil regulatory jurisdiction.
Yeah, that makes sense. Thanks for adding that in too. I'd also encourage folks, if you want to follow this, to sign up for one of the NARF email lists as well too, because there's going to be a lot of action around this case and to undoing what might have happened with this case, probably for a decade or more. And you can bet that that's going to be part of our emailing system too. So that'd be a way to keep up on it as well. Thanks for stopping me, Joe. That's good. As the United States started to move west, so we're talking about early to mid 19th century, or early to mid 1800s now. First off, they moved the tribes that were east to the west in order to clear the east. So basically the attempt east of the Mississippi River was to get the tribes out of there and move them to the west. And so as a result, a lot of folks were moved to the west into Oklahoma, which was called Indian Territory at that time and was set aside to be the place where those tribes were moved to. So a lot of tribes with Aboriginal lives in the eastern US got moved to the Oklahoma and elsewhere in the West. There were trails of tears, death marches, all sorts of moving of the people at great suffering over these times. And a lot of times different tribal nations had different walks like that at different, over the years. In other words, not everybody made it on the first walk. They marched other people later from that group and then later again and so on. So multiple trails of tears for the Cherokees, for example. Sometimes people would stop along the way too. And so you end up with folks like Potawatomis, who are basically up around the Great Lakes originally, ended up also with reservations in Kansas and Oklahoma as well. So just each individual tribe's history tells why those folks are scattered the way that they are. But if people were in the east of the Mississippi, a lot of them were moved over to the west, and a lot of them to Oklahoma, to what became Oklahoma. So for example, also there was an Indian Removal Act in 1830s, just carrying out that policy as well. The Supreme Court cases we already talked about defined the trust relationship, the domestic dependent nations, along with making the tribal nations domestic dependent nations. That entailed a responsibility to take care of them too. They weren't able to, based on what the United States said, they weren't able to govern their own affairs entirely. So therefore the United States has to help them when need be. So that's the other side of that coin, basically, legally. As the movement got to be west of the Mississippi, tribes reserved their lands, some of their lands, within treaties. That became the policy preference for the United States, to enter into treaties where tribes would move out of certain areas or grant access to settlers, and agree to stay within certain lands that they reserve for themselves. In addition to this, tribes also reserve treaty rights outside of those reservations as well. So you might have, well, for example, the Great Sioux Nation, which is the Oceti, Sakowin, Oyate that I'm a member of, reserved basically the western half of South Dakota plus in our treaties, but then we reserved hunting rights over through Wyoming and southern Montana. So at least as big of an area, we reserved the right to continue to hunt and fish and gather, in addition to the lands that we reserved as our original reservation in the treaties. And that happened time and time again. And so a lot of fishing and hunting and gathering rights exist for Native people outside of their reservations, or even their original reservations, because as we'll find out, a lot of reservations have been reduced in size under American law. I like to point out that it's kind of ironic that the first healthcare appropriation for Indian health was basically a blowback from the smallpox as biowarfare policy, where they provided funds for smallpox vaccines for natives in 1832. They had to do that because smallpox was rifling through Indian populations, and Indian populations were interacting with settlers at forts. And so the settlers were getting smallpox from Indians. And so the federal government realized in order to protect its settlers, it needed to also vaccinate Indians. So the biowarfare kind of came back around a while later as natives were continuing to suffer from smallpox. Notably, in 1849, the Bureau of Indian Affairs was moved to the Interior Department, so with the other wild things in nature, away from the War Department, so away from the enemy. So that's probably a step up, I guess. In this history, this is where I like to point out that unique situations abound. We already talked about Oklahoma and why there's so many tribes there, and kind of we started talking about what the status of their jurisdiction is, although that's really a confusing box of issues. Some unique situations that are just really clear is California. California had been colonized by Spain, and then by Mexico, and then by the United States when it took over. So there's different rules from all of that. And tribes have had relations and agreements with all sorts of those, with all of those different colonizing governments. Alaska is another situation because of later interaction by the United States. The United States kind of perfected on its tribal government and tribal reservation system and created Alaska Native corporations, kind of a refinement, I guess, that made it easier for the federal government to get more land and provided a different governance structure. So that's an interesting case that's worthy of its own 2-hour talk, not even just an hour. And then Joe, what do you want to say about the Pueblos? Another entirely unique and fascinating situation too, compared to the big picture that I'm talking about here today.
Yeah, well, first on the big picture regarding the relocation and the removal, I think one thing to add there, if I may, is that it's helpful, a very important context to the Trails audience here, because just because a tribe is no longer present where a trail may be, or is near or adjacent to it, it doesn't mean that there's no longer any tribal connection to it. I mean, the tribes, most, I would say, retain some kind of Aboriginal ancestral type connection to those lands where they originally inhabited. So I just wanted to make that point. Regarding the Pueblos, the Pueblos in general were not removed or relocated per se. I mean, we moved ourselves, but that was within our own migration type histories. But for the most part, when the colonizers came, we were in our present more or less locations. So we were recognized as such by separate sovereigns, three at least: Spain, Mexico, our federal government. But our homelands are not only our present location, but also the greater ancestral land holdings that we have that surround the present day reservation lands. So I think that's a key thing here to point out. Another difference with the other types of tribes that exist there is that, and I think you touch upon this later on in the slides, is who is an Indian, right? In the early years of the Pueblo history, we were not considered Indians. The USV Joseph case, I believe, set us apart from the rest of the tribes. Like we weren't the same in terms of our culture, our way of life. We were compared to other tribes, like your tribe, Brett. We weren't as quote unquote savage as your tribe, so we must not be Indian. So we were excluded from the protections of the federal government policies at that time, and in a later case, USV Sandoval restored those protections. But that that's at least a couple of distinctions there. There's others, but I know we're limited on time.
Thanks, Joe. Yeah, so then kind of picking up the pace, I guess, a little. It's funny how time flies. The next came in the mid to late 19th century, a period of Indian wars and a policy shift towards assimilation and allotment. So starting with President Grant, who had a peace policy, they enacted assimilation through Indian boarding schools, where the policy was actually to kill the Indian inside the person in order to save the man. That's stated by the person who was in charge of this policy, Lieutenant Colonel Pratt. Also at this time, so the idea is educate Indian kids in order to make them not grow up in their culture, but to learn how to assimilate into United States culture. Also, allotment came to rise during this time. That's when tribal lands were allotted to individual Indians rather than having the tribal nations own the land as a group. And so that was seen as being important, so that then Indians could become farmers, learn how to farm the land, get used to private property and ownership, and then assimilate that way. This also allowed the breach of the reservation boundaries, because individual allotments were given to people, typically like 80 to 160 acres, depending on the productivity of the land and the location. And that was typically, I believe, given to male heads of household. And in some cases, there were allotments provided to women and children of smaller size even. But any land that was left over after that was seen as surplus. And so the reservations were opened up to settlement on that excess in quotes land. And that's where you get homesteading coming in to breach the reservation boundaries. There were also competency hearings at the time. If Indians were determined to be competent, then they would be able to alienate their land holdings that they had gotten through allotment and so on. So it'd be another way to get at more land, basically. And it's also interesting that during this time period, traditional practice were actually outlawed by the Department of Interior, who issued in the years listed here, 1884, and then 10 years thereafter, and another 10 years thereafter, issued civilization regulations, even though these regulations were never authorized by law. So they were laws, policies on the book by Interior, even though Congress never told them that they could do that. Well, if you're a Department of Interior official enforcing the laws, you don't really look to that issue of whether it was authorized or not. You're told to enforce the law. So they were outlawed, even though that was illegal. Also during this time, the Major Crimes Act came to be. In that case, reservation boundaries were breached for criminal law. And I don't have time to go into the background, but the start of the erosion of jurisdiction within the boundaries of the reservations during this time. So you ended up with reservation boundaries that look a lot like this. This is more modern, a more modern map of reservation boundaries, but this is about what it looked like after the end of this period. So after this kind of bleak period, we started to come out of it, but it took a while to get there. In 1921, the Snyder Act authorized recurring appropriations for Native health. That's the first time that recurring appropriations were authorized. And then in 1928, the Miriam Report basically went around the country and explored the status of things on the reservations. And it basically found that they were squalid, terrible condition. And it called for development of all that is good in Indian culture rather than crushing it out. So a marked 180-degree shift from the old boarding school policy of killing the Indian in order to save the man. Now it's let's save the good of the Indianness for people so that they can live. So that pendulum swung back in a hard way here. As a result, we had the Indian Reorganization Act in 1934, which set up tribal governments, pretty much boilerplate model. I've seen my tribal constitution, compared it to a constitution from someone in the Northwest, and compared it to one of the pueblos in New Mexico, and it looks like an almost identical constitution from the Indian Reorganization Act, despite the fact that those nations are really, really different people in how they organize themselves traditionally and how they live. So the boilerplate was a matter of economy for the United States, I'm sure. And then also tribal courts came to rise during this time as well. There was an Indian Claims Commission that attempted to settle the issue of the fact that a lot of land had been taken and no compensation had been provided. Turns out that was a model for how to get off the hook for the cheapest possible. I don't want to go into that, but would argue that it wasn't very fair at all. After this period of reorganization, the pendulum swung back towards assimilation, only this time it took a little bit of a different approach. It was more about termination and relocation. Tribes were actually just terminated from federal recognition if it was determined that they might be able to stand on their own and it would be good for them. So 109 tribes were just wiped out. The impact was pretty severe on those tribes. And they sought later to be reestablished and re-recognized, basically. Individuals were relocated to urban centers in a really big way. So this is why you have a big urban Indian populations in certain cities where they were targeted to be sent, like Los Angeles, San Francisco, Denver, Dallas, Chicago, New York. People were basically told that they could go work in the cities and provided some training for those jobs and asked to move away, in order to pursue the economic opportunities. These were always entry-level jobs and labor jobs, though nothing. It wasn't like a big educational push or anything. Public Law 280 was also passed during this time, which allowed states to have criminal jurisdiction within Indian countries. So not just federal jurisdiction, but now state jurisdiction. This only occurred in certain states, but more were added later. And how this actually works out depends on not only the state, but also the reservation in a lot of cases. So you have to look at the individual tribal histories in order to really understand how it all works out. The Transfer Act also moved the Indian Health Service to the Public Health Service, which was under the Department of Health, Education, and Welfare, which is now Health and Human Services. And also important about this act, it allowed the secretary to contract out healthcare services subject to tribal consent. So it allowed third parties to be able to start providing healthcare for Native people rather than the federal government. After this didn't work very well. So there was a Kennedy report which studied Indian affairs around the country again in 1969. And guess what? It showed that things were not good, that termination and relocation weren't working out either. And things were tough on the reservations again. And so this was at the time of the civil rights, and with the synergies about what was going on, there was a lot of progressive legislation that came out shortly thereafter. So we have this series of acts that are listed here. Yeah, with respect, I mean, without much time to talk about them, just kind of take note of them. We're basically trying to legislate in all sorts of areas. One thing that didn't happen during this time that was tried to happen, it was forestalled as a political issue. we sought a right of action for access to sacred sites on federal lands. And that's something that's relevant to trails, and it's something that refers to what Joe mentioned, where we maintain connections to these places, even though they're not on our reservations. We sought to have a right of access. That piece of the legislation was never passed as a political matter. And then the courts kind of worked to make sure that that wasn't a legal right that we had in court anyway, too. So that's been kind of tough. And people on trails will deal with that. Also, though, as these things took place, it became clear that what was really wanted was government-to-government consultation and relations between the tribal nations and the federal government in order to talk about affairs as partners, because instead of having natives having stuff done by the federal government for natives, it became recognized that the federal government ought to be talking to natives about these things in order to do so more effectively, I guess. So we end up with government-to-government relations being prominent in the Clinton administration. That was followed by the George W. Bush administration, again followed by the Obama administration, and kind of finessed in their own style. I don't think the administration after Obama did much. A lot of natives tried to stay low during that administration, so we didn't get our heads cut off, basically. They didn't do a very good job of consulting, really, but the Biden administration appears to be trying to do consultation in a decent way. So on to current issues, just to give you an overview. One issue that comes up for a lot of folks is who is native. It's worth pointing out that this is a political status, not a racial status, and it's based on groups, not individuals. So the real issue is the tribes have relationships with the United States, and sometimes tribes have relationships with their state governments that are important in this. And it's those groups' relationships that are relevant, not the individuals. So the issue is, has a tribe been federally recognized? And then after that, the tribes, the groups themselves get to decide who their members are. So that's how you get to who's an Indian, basically, because the tribe recognizes that person as a part of them, just like the United States recognizes who its citizens are. So tribes have that same ability as sovereign nations. I'd like to point out there are federally recognized tribes. There's standards for that. And then there are state recognized tribes. So some tribes are recognized by their state that surrounds them and not by the federal government. Sometimes that's by choice of that tribe. They choose not to pursue federal recognition for whatever reason. Sometimes they probably can't get federal recognition. It could go either way. And then there's also unrecognized tribes that, were you to sit with them and learn about them, you would see that they are native people who still practice traditional cultures of their ancestors and so on. They just choose never to pursue recognition. It's still there. I'd like to talk about tribes versus nations as well. Like, for example, I said that I'm part of the Oceti, Sakowin, Oyate. That's the 7 Council Fires people. That's the name of a nation which was called the Great Sioux Nation by the United States at treaty making time. But we have, I haven't ever counted, but we have at least 12 tribes that are, remnants of people from that nation. So we're split up into all sorts of tribes, tribal nations on different reservations and so on. So that can be an issue at times. People are broken up into different reservations. That's part of a divide and conquer that was seen as something worthwhile doing by the United States. So, Joe, you got anything to add before I?
Well, just briefly, I think it's critical that this who determines who, and you mentioned tribes determine, right, who is a native within their own tribal membership rules. That whole concept, I think, was recognized by the U.S. Supreme Court during the self-determination era that you had pointed out in your prior slide, in the 1978 U.S. v. Santa Clara Pueblo case. So that at least adds to that notion that we are in the era of tribal self-determination, and much of what happens within the tribe should be and is left up to the tribes to determine themselves. So I think that can be a good segue to other things that we'll be talking about as well later on.
Yeah, good point. Thanks, Joe. We'll just move on to the next set of issues. types of rights, just to mention them so that you're aware of them. I mentioned Aboriginal rights that people have always had since before the United States came, and sometimes those still exist. And so sometimes it's just never been addressed. And so that's a possibility that Aboriginal rights still exist in places. There's also the next kind of layer would be treaty reserved rights, where people reserved rights in a treaty, and those haven't been extinguished by any act of law. And so they still exist as well. So you find tribal folks with treaty rights to do things off of their reservation and within their Aboriginal territory. The rights are reserved in a treaty. And then there's a congressionally or otherwise granted rights as well, rights that could be granted from the federal government for whatever reason. So just different types of rights to think about. Rights are really important to people legally. Then looking at recent trends, just to provide you an overview, again, still there's an increasing urban population. More than 50% of Native Americans now live in urban centers. You wonder if we're back in a trend towards assimilation, away from self-determination. We've got a huge erosion of sovereign immunity in the courts that would trend towards assimilation. We've got an erosion of jurisdiction that the Supreme Court is apparently hell-bent on pursuing right now. There's a recent Tribal Law and Order Act that attempts to close a jurisdictional gap, but in order to do that, so in other words, attempts to give tribes more jurisdiction within their territories again by legislative action. But the trade-off is they have to do basically American law type protections for defendants, a lot of times which tribes aren't able to provide because of funding. So that's a give and a take. And I would argue it's towards assimilation because they're actually forcing tribes to do something that they otherwise wouldn't do based on their own ways of dealing with things. Another hot issue right now is the issue of murdered and missing Indigenous women and other people. It's becoming more and more clear to the mainstream, to the outside, that a lot of people have been taken basically from our community, stolen and trafficked. And for some reason, that's really at high levels within Indian country. And so we're getting some awareness, and that helps because we get allies to help with that issue as well. But that carries with it trauma when that happens to family members. And so it's really important, and it's good that we're getting help. Joe, other recent trends before I move on to the slide. I'm really going fast now because of time. I want to leave time for some discussion.
No, I don't have anything.
Okay. So then looking ahead to the future, what's next? It seems like maybe we're maybe postured towards a time of reckoning and rejuvenation. There seems to be a tribal renaissance where tribal folks are recovering more and more of their ways of doing things and learning how to institute traditional values and practices within the modern world. So for example, one of my projects at NARF is to work on peacemaking for tribal nations, or traditional dispute resolution. And there's a lot of tribal interest in that all around the country because they find that the tribal courts don't work as well. They're not funded enough, and frankly, they can use tribal values better in a more traditional system and thereby take better care of their people. Are we moving towards reconciliation? In order to do so, we need to tell the truth about what's happened in the past, and there needs to be a taking of responsibility for what happens, and then we can move forward towards healing. Well, that's what's attempted to be done about the boarding schools. The Secretary of Interior has an initiative going on right now where they've took a preliminary look at what happened with that in the past. So it's the United States starting to tell the truth about what happened. Needs to go into more depth because you can't just check the box real quick. You got to tell the whole truth. But to take responsibility and move forward could happen after that too. Maybe that's the way things are going. Definitely within Native populations, there's an effort to reconnection with ancestral lands that's increasing, trying to figure out more and more ways to reconnect. And there's a land back movement where tribes are trying to gain back control of land as much as they possibly can as well too, in order that they might more effectively basically execute their responsibilities with respect to that land. That looks a lot like stewardship and caretakers, and it also can look like performing ceremonies and other sacraments in particular places, but basically people doing what they're culturally supposed to do in order to have a better relationship in that place. I think it's a matter of worldview. The indigenous worldview, people are trying to bring it back and reassert it, and it's something that's probably needed to be done. In the Euro-Anglo-American system, we talk about rights. Those are granted by a sovereign. That means they come from higher above and they're held against others. So they're generally granted in the United States by the governments. Some rights in the United States are said to be granted by God, inalienable rights and so on. But it's always the hierarchy. And when we get mad, we appeal to somebody within the hierarchy to get our rights enforced against another person. On the indigenous side, just knowing the different indigenous cultures that I've been around, there's not so much a discussion about rights. It's more about relationship, respect, responsibility, and reciprocity. A lot of natives, so we're talking about the 4 R's now, and that supplants the idea of rights. That's a more egalitarian view. It's mutually responsible. It's a more nurturing view as opposed to the hierarchical view. It's less economic. You can't compensate problems as much with money in that system. It's more about responsibility for wrongs done and so on. And it reflects a more interdependent view about how we are with each other and with the environment and with other inhabitants of the environment, as opposed to an individuated and independent view that comes from the Euro-Anglo-American and colonizing worldview. So that's an awful lot in a really short time, but that's it. I'd like to say wopila. It's translated as thank you a lot of times. I'm told that it can mean something more like there's been a state of honoring here, and that's really what's happened when you sit and listen to me for this short amount of time. And so I do want to say wopila, thank you.
Thank
and
you.
Now we've got some time to talk.
Thank you so much, Brett and Joe. We do have a couple of questions in the chat. Let me see here. Rob asks, why did colonizing powers engage in treaties? Why did they feel that tribal rights should be recognized at all?
It's been said, and I haven't seen the studies, but it's been said that it was determined it was cheaper to enter into a treaty than it was to win a war against a population. And if you look at it, that's kind of the way it proceeded. Initially, there were periods of Indian wars in the East. And then there became a preference for the treaties among all the colonizing nations. Yeah, like I say, it makes sense too. I mean, wars are expensive undertakings, and you have to about completely vanquish somebody. Whereas if you can get them to agree, then maybe that's better.
Thanks, Brett. We have another question. Does the term Indian country have a common definition? Does it mean the same thing to Joe as it does to Brett?
The second half of that question is even tougher, but there is a legal definition of Indian country. That's in law. I don't have a quote for you, but there's definitely a legal definition. So and a lot of court cases hinge on whether something happened in Indian country. It's basically things like tribal, within reservations clearly, and then sometimes the kind of border areas, dependent Indian communities that are dependent on reservation economies and so on work into it. And as you get towards the edge, it gets a little fuzzy to where you actually argue about whether a place is in Indian country or not. But there's a lot of places that are clearly within Indian country, and a lot of it has to do with federal ownership of the land in trust for Indian people. Joe, you got anything to add on that one?
No, I agree with that notion that, there is that legal definition that exists out there. And, the impetus behind that is, well, not really the impetus, but really the effect of it is that it tends to box us in, right, within certain defined boundaries. But generally speaking, for many tribal people, I think when they look at Indian country, they look at beyond those brightly defined boundaries towards ancestral homelands and so forth.
Absolutely. And that's part of the reconnecting that's happening these days. People are starting to free their minds from being bound by the reservation boundaries.
Thank you for that. If anyone in the audience has a final question, feel free to put that in the chat. We don't have any more questions so far, but Brett or Joe, if you have any final words, I welcome that.
Joe.
Well, I want to say that, the last part of what Brett had covered, beginning with the self-determination policies that are existing there, I think is very helpful to lean on and recall what they mean in terms of self-determination, because that is the backdrop, I believe, to interpret any of the rules, the regulations, the policies, the procedures, the laws that will impact the trails system here. So it's important as a background to refer back to that as we get into the weeds of those policies and procedures of consultation and engagement and so forth.
Yeah, thanks for that. We do have one more question in the last couple minutes. Can you speak briefly on the barriers to federal recognition built into those regulations?
I can just hit on it. Basically, the regulations set out some criteria by which whether a tribe should be recognized or not by the federal government are judged. And that includes like continuous existence and having some sort of relationship recognized in the past by the United States and so on. So just to name one, I mean, this could be a half-hour talk, but just to name one, there has to be historical documentation of continuous existence and functioning as a group. And it may be, you know, these tribes don't have any recognition. It may be that they lost their records of having meetings over the course of a decade, or maybe there was a fire in somebody's house where they kept the minutes and that's gone. Well, that's a barrier, right? Because now they can't prove with evidence that with documentary evidence that they existed during that time period. And that could subject them to an adverse decision. In other words, have them not be recognized by the government. Just one example, but all I have time for. And if you look at the recognitions at the regulations for recognition, you'll see all sorts of possible stumbling blocks.
Thank you so much, Brett. I feel like we might have time for one more question, so we'll squeeze that in before we wrap up. Do existing agency policies help to provide some of the access to ancestral sacred areas that legislation currently does not? Do existing agency policies help to provide some of the access to ancestral sacred lands where legislation doesn't?
I don't know. I mean, typically agency policy has to be authorized by legislation. So it'd be hard to imagine that a policy would be more permissive than legislation authorized. It's maybe the case that individuals make a difference. I guess I'm aware anecdotally of individual administrators who allow natives to do things that natives need to do culturally in places, and it's not necessarily something that's talked about or written about in terms of law. So that sort of a policy, I think those do exist at times, and it depends on an individual basically willing to stick their neck out and do something that's outside of the bureaucratic structure. But that's all I'm aware of. And like I said, I think the fact that legislation typically authorizes policy, that, you know, it's just, that's the way it usually works. Joe, anything that I'm missing?
Well, sometimes, and not specifically speaking of any a policy or procedure, but what sometimes come out of those consultations or engagements or standalone separate agreements, right, to access and so forth, and that can be a lot more permissive than what the law would allow.
Yeah, that's a good point. Thanks.
Great, thank you so much. I guess that's our time. There are a few more questions in the chat, so I will work with the presenters to get those answered for you. And I believe we will be sending a copy of the slides for people to look at afterwards in my post email with the recording. So I just want to say thank you to everyone for attending today, and a very, very special thank you to our presenters, Brett Lee Shelton and Joe M. Tenorio with the Native American Rights Fund. We did put a link in the chat for the second part in this tribal consultation series, so please check that out and register. And I will also mention that registration is now open for PNTS's National Trails Workshop in Albuquerque, New Mexico, November 2nd through 4th. I will send out a little bit more information about that event as well. It's going to be really, really exciting. Yeah, working there's going to be some sessions focused on working with Indigenous communities and stewardship training. So that'll be really exciting. Okay. And I think that's all I have to say. So please follow PNTS on social media and keep up with what we're doing. Thanks again for attending. And I hope you all have a wonderful rest of your day. Thanks.
Thank you, everyone.
Thanks, everyone.